Good evening, this is John Milburn for Laws 11057. This is Introduction to Law. We're into week 9. Thank you very much for a number of people joining us for the live session. As always, I do appreciate it greatly. Now, before we start, do we have any questions generally about the unit, the assessment, any of the content for this week or any of the weeks indeed? Just to get you warmed up, that's all. All right, nothing for the moment. The thing that you may have noticed on Moodle page this week is the big red button at the top left-hand corner of the screen. Just share the screen and you'll see the landing page, as I describe it for Moodle, for this unit. Top left-hand corner, have your say, and thank you for those 2 students who have already provided their information. Now, could I say that the information you provide is anonymous? I don't know who those students are. I will eventually get to see some feedback, but I don't know who the people are that provide that feedback. So I'm going to encourage you now to provide some feedback at some stage during the next few weeks, if you would. It's your opportunity to provide information that might assist in terms of how this unit is offered into the future. And I'm certainly keen to have you complete information in a general sense. It's important to the university. It's certainly important to me. Now, on a broader scale, this week is, for want of a better term, feedback week. So if you have had any difficulties with the unit, the study, the textbook, the reading material, the assessment tasks, or anything else, please feel free to raise some comments or questions in Moodle Q&A, or if you wish, send an email to me. So I'm keen to see what you think about the unit, what you think about the assessment regime, and any further assessment that you might have for the future in this area. All right, so let's just move on from where we were last week. And we started to talk about access to justice and the concept of the law being available in a wide range of different activities and to a wide range of people. So some of the areas of practice, and I mentioned this at the tail end of last week, where we think about how law can provide some degree of social justice is in criminal law, immigration law, human rights law, mental health law, guardianship administration, child protection, domestic violence, environmental law, family law, personal injuries, and anti-discrimination. They're just a few. So can I invite you to let me know if there are any other areas of practice that you believe the concept of being committed to justice and having access to justice is potentially important. Anyone wish to make any comment about the list that I rattled off? All right, if something comes to mind, please let us know. So international humanitarian law. Thank you, Gary. That's a good contribution. Any others? All right, so when you've been studying this unit, I guess you came in not necessarily wondering or not necessarily knowing which way I would take you, and quite probably wondering why I've taken you down certain routes at various times. The law is very broad, and introduction to law is therefore by necessity very broad. And we're trying to deal with a number of concepts all at once. Now, we've studied the law generally. We've provided some history about the law, both English and Indigenous. We've got some basic concepts, law and equity, common law and legislation. We've worked out the priority at looking at law, legislation, case law as the primary sources, and then the secondary sources. We've tried to learn how to interpret the law. We've tried to learn how to answer legal problems, legal reasoning, legal logic, such as the IRAC method, when you're confronted with a problem. And in a way, we're trying now to put all of this together. So a good way to think about how to approach a legal problem is to adopt, for want of a better term, a holistic approach. Now, here's the problem. If we truly adopt something which is holistic in nature, we're going to go a lot further than what we've discussed already. So tonight, as my proposal is that we broaden the horizon yet again. So if it wasn't broad enough already, we're going to stretch it further. So I'm looking for feedback tonight from you, because as we discuss topics, other things may come to mind. Please feel free to unmute your microphone and to contribute. Feel free to use the chat facility. Let's start the discussion about access to law, being committed to justice, and the way in which social justice can be served through the law by thinking about some basic principles. So the law is partly substantive and it's partly procedural. Does anyone know what I mean by that basic distinction? That law is partly substantial, partly substantive, and partly procedural in nature. All right, so when you're studying civil practice, for example, you'll have a lot to do with the Uniform Civil Procedure Rules. They're the rules, the regulations that guide you in the process of how you run a civil action in various ways. So a lot of it relates to the procedure. And the procedural mechanisms there to build the structure around which the substantive law is able to operate. So family law, for example, works around a basic structure within the court system, within the legislation, etc. So from a procedural law perspective, it's not just boring mechanics. There are some very important principles. And these, if you like, lay over the top of the substantive law and should always be considered by you when you're running a substantive law argument. So if, for example, you're running a family law argument, one of the basic principles is that your client is entitled to have a fair hearing. Now, it might seem obvious, it might seem trite, but when you're in a case and you feel that things aren't quite right, then it may be that you are of the view that you're not getting a fair hearing for whatever reason. So I talk about the toolkit a lot. I talk about this document, which is meant to work for you. And if you're thinking about a legal problem, you might want to incorporate in some way this ability to have or be ensured a fair hearing as part of the mechanism. I'm just going to stop there because I know that many of you have already uploaded your assessment and you probably think, oh, it's unfair that I'm talking about the toolkit now. The toolkit is something which is intended to be a work in progress. In other words, don't just stop once you've submitted the work. This is meant to be a live document for you to carry with you into the future. Whether you're studying law or whether you're doing other things, it's meant to be something that you own in the sense that it works for you. So if I keep referring to the toolkit, even after the assessment is complete, I hope you understand why I do that, because I want you to walk away from this unit with a very good portfolio and a very good toolkit so that you've got two things that you can build upon into the future. Then the third assessment is all about providing some a response to problem questions or essay questions. So back to procedural fairness. Obtaining a fair hearing is an important factor. And we can break that down into a number of different sub areas. One is being given a chance to test the evidence that's presented against you. And can anyone think about the traditional way that lawyers test the evidence presented by the Crown or by your opponent? Thank you, Rachel. Thank you, Gary. Cross-examination. All right. So cross-examination is the usual way we test. So that's what courtroom dramas are all about, cross-examination traditionally. But again, when we look at procedural rules that apply to cross-examination, we'll find that there are many. One leading one is a thing called the rule in Brown and Dunn. Has anyone heard about the rule in Brown and Dunn? It's really an evidence rule, but in short, what it says is that if you're in the process of cross-examining a witness and your intention is later to lead evidence that is contrary to what this witness is saying, then you owe it as procedural fairness to at least put your version, put your case to this witness so they can make comment upon it. Does that make sense? So if you have, for example, a psychologist in the witness box and you're challenging the findings of that psychologist, and you've got another psychologist who will provide evidence to the contrary, then while you've got the first psychologist in the witness box, your obligation is to at least put your case to them and say, this is the case, isn't it? So that they can comment. So that's what we call the rule in Brown and Dunn, and it applies in civil and criminal cases. So when you're thinking about that concept, I'm going to digress for a moment, share the screen, and invite you to look at a thing called the bench books. So the Supreme Court Library of Queensland produces, amongst other things, the bench books. And the bench books are those things which are traditionally used by members of the judiciary as a guide to certain legal principles. So the fact that we have public access to this material is of great resource. So if, for example, you wanted to know about the rule in Brown and Dunn in the context of criminal law proceedings, then you can go to the Supreme and District Court Criminal Directions Bench Book, pan down, and you'll see there Rule 32, or Bench Book 32 rather, and these numbers do change. At the moment is the rule in Brown and Dunn. And I've just selected this one to broaden your horizon. No, for some reason, I'm not able to directly access this now. I'll leave you to look at that, but you can trust me when I say that it will open as a Word document. I just don't want to go through the process of having to save it and then open it. It used to just open automatically. It doesn't now, for whatever reason. So that's the bench book series, and it's a great resource. So again, I'm layering a few things here. I'm talking about the way in which procedural rules overarch those substantive rules, and it's all to do with fairness. Another thing is that you have generally the right to refuse to answer questions that might incriminate. I guess the question is, well, where is that law contained? I'll leave you to ponder that. And also, are there any exceptions? And there are. So, for example, there are things called compulsive hearings, Crime and Corruption Commission, the Australian Crime Commission, ASIO, for example. In some circumstances, you can be compelled to answer. So the right against making statements that are incriminatory will be overtaken by a statute. And another thing that's being argued regularly, and I think I can say from what I saw on the news today, that the legal team for George Pell are arguing this, that it's to do with the onus and the standard of proof. So the question is, overarching all of our laws, these procedural rules that relate to, well, who has the task of proving something? And if so, once we've determined that, to what extent must they prove it? So in a criminal prosecution, I can ask you this, who has the onus of proving the case? Generally speaking. Prosecution, the Crown, prosecution, very good. And to what standard of proof must prosecution prove its case?
Beyond reasonable doubt.
Thank you, Paul. Excellent. And Gary came in with a written response at the same time. In a contract matter or a civil matter, generally it's the party that is bringing the claim that carries with it the onus of proof, And the standard of proof generally in civil proceedings is what?
On the balance of probabilities.
Excellent, Paul. And Rachel came in at the same time as well. So on the balance of probabilities. There are some exceptions. Has anyone heard of, and there are some refinements. So we'll talk about a refinement to that rule of on the balance of probabilities in civil matters in different ways. So, and it depends on legislation as well. All right, so I might move on and we'll talk about some other things. So the next is retributive justice and contrasting that with restorative justice. So now I'm talking about criminal law proceedings. When we talk about justice in criminal proceedings, it may be that the overarching idea is to seek retribution, which is essentially to punish, but contrast that to restorative justice, which is concerned about restoring the healing to the victim and reintegrating the offender into the community. So if you're acting for a client in a defence matter in crime and you're thinking about issues more broadly, which is part of the theme for tonight, rather than simply restrict yourself to defending in court, can you think of any other way that you might be able to dispose of the matter lawfully, but in a way that deals more with restorative justice principles rather than retribution? It's a vague question. Ah, very good, Gary. Glenn came up with an idea as well, yes. So ADR, mediation. Thank you, Renee. So it is possible to refer matters that are criminal law based to mediation through the restorative justice principles, and that's something that you should consider. So the basic philosophy of restorative justice is that the crime is against an individual victim, it's not against the state. And the offender needs to be held accountable and reprimanded by all stakeholders. Okay, so let's now talk about some of the issues that are a challenge when it comes to having access to justice. Can you think of any impediments for individuals when it comes to having a just outcome?
The cost of a lawyer?
Yes, so Paul said cost of lawyer. Rachel came in almost a dead heat and said a lack of finance. Absolutely. And I think that's probably the first thing. And that's always top of my list as well. Are there any other things that come to mind that might create difficulties in accessing justice?
I imagine another one would be not knowing that you can access justice in the situation to which you are in.
Ah, very good. So lack of knowledge is important. Yep, thank you. Language barriers, says Emily. Yes. So looking at the individual capacity. Tani says mental capacity, yes, is very important as well. Rachel says literacy, and Glenn says understanding of the law. Okay, so they're all important aspects. Can I ask you this question? Do you think having a tribunal or a court that says that lawyers are not allowed to appear, does that provide greater access or does it deny access to justice?
I imagine that would deny access quite a deal.
Deny access to justice? Any other thoughts? Rachel?
I think it depends on the circumstances. So, for example, like a small debt claim, yes, that provides greater access to justice because the amount of the claim is small and the costs of engaging lawyers would far outweigh the cost of the debt. But in circumstances, say the guardianship tribunal, where, you know, there may be competing views on who should have, you know, guardianship of, you know, an incapacitated adult, then I think that's where there should be a more formal sort of court process, because the likes of, you know, the public trustee and the adult guardian have got, you know, solicitors, in-house solicitors, to be able to sort of, you know, deal with those issues, whereas a lay person wouldn't.
Okay, good. All right, thank you, Rachel, for your perspective there. And you hit you were correct, I think, Rachel, when you said depends on the circumstances. And Paul, I think the example you gave, yes, potentially there is a lack of access to justice, but in other ways, having lawyer-free jurisdictions and removing the threat of costs against you if you lose arguably creates a greater access to justice. So it depends on the circumstances. But there are certainly some challenges associated with self-representation. We've identified some of them tonight. Literacy, language, access to and understanding of the law were some of the things that were raised by Glenn and Rachel, Tani. So these are all important things. Lack of familiarity with the process, and the costs aspect is very important as well. So that can be a great impediment. So for example, in environmental law, it may be that as a concerned citizen, you really do want to oppose something which is being developed, but a great impediment to you might be the risk that you're up against a multinational with huge financial resources and lawyers that cost a lot of money. And if you go to court, there is the risk that you may lose, and the court may say you've now got to pay their legal bill, which could amount to much more than tens of thousands of dollars. It might be in the hundreds of thousands of dollars. So legal costs is also something that must be considered within the context of whether someone truly has access to justice or not. So there are issues relating to the cost of legal proceedings and deterrence. I think also, if you happen to be the sort of person that might be involved in street offences, you're more likely to be the target of prosecutions, because it's much easier to prosecute a low-level street offence than it is to pour huge amounts of resources into a complicated corporate crime, a corporate fraud matter. Do you understand? Even though the corporate fraud is likely to be far more serious and far more devastating. So that's an issue. Can I just ask this generally? I assume that you've all heard of mandatory sentencing. In other words, where Parliament says, in a Get Tough on Crime initiative, we are now going to impose an obligation on judges to imprison those people that are convicted of, let's say, grievous bodily harm. Does that create better access to justice or worse access to justice? What are the fors and against for that type of initiative? Does anyone wish to advance an argument in favour of or against mandatory sentencing?
Again, I
Yes,
think
Rachel?
it really depends on the circumstances. Again, like if someone intentionally goes out and, you know, stabs someone, then I guess, you know, like mandatory punishment then would be warranted. But if another person, say, got into, you know, just a fight on the street and it resulted in, you know, grievous bodily harm charges, then I think that's where the mandatory punishment sort of isn't warranted, because it could just be, you know, spur of the moment, you know, unconscious decision and unintentional.
No, thank you very much, Rachel. So it depends on those circumstances. And some of the other comments, Catherine saying, better outcome for society is a greater deterrent. Katie, it feels it comes down to context. Emily, context and purpose not taken into consideration. So I'm not saying there's a right or wrong answer, but it is important that you think about it. And I like your approach, Rachel, of taking that balanced view and looking at it from different perspectives. But certainly it's an issue that will be around for considerable time. And as lawyers, your obligation is to have views on these things as well. One thing we've noticed in the last 20, 30 years is the rise of different ways of resolving disputes other than by court. So alternative dispute resolution is becoming a huge area of practice. And some of those, and I teach ADR at this uni, which I'm very fortunate to be able to have done for the last 5 years or so. Some of the different types of ADR, we've got negotiation, partnering, dispute advisors, dispute review boards, facilitation, conciliation, mediation, collaborative law, expert appraisal, expert determination, early neutral evaluation, mini trial, referencing, adjudication, arbitration, hybrid hearings, and there's more than that. Now, the reason for mentioning that long list of ADR options is to, again, broaden your horizons. When I went through law school, it was all court or nothing. Now there are so many different types of ways to resolve a dispute. And that makes it difficult for lawyers because you have to be on top of this. Now, a client is unlikely to come into you and say, I have this commercial dispute and I've been doing some research and I'm weighing up whether it's better that we approach this on the basis of arbitration or litigation. But you need to be able to provide that response and give an answer to say whether you favour or recommend arbitration versus litigation. To give that response, you need to know what arbitration is, what it means from a practical perspective, what are the pros, what are the cons, etc. So it's not just now a matter of knowing the law, we have to know the procedures that might be adopted either in a courtroom or somewhere else. And I'm not asking you to go out and do some undertake some searches on collaborative law, for example, but you need to understand within the context of a certain type of legal dispute that collaborative law may be a very realistic option and a good way to resolve the dispute. Does anyone know what collaborative law is, by the way? Bonus points for this if you do. Or the area of practice where we typically see collaborative law. Very good, Rachel, family law. So collaborative law is a way of resolving family law disputes. Mediation is also big in family law, and arbitration is becoming huge in family law. Next week, in the Federal Circuit Court, as I recall, there are about 250 matters being mentioned in a huge blitz to see if, amongst other things, matters that are otherwise destined to be heard by a court can be referred to arbitration. So again, we're looking at broadening horizons tonight. So you need to layer this and think about different ADR options instead of just thinking about the substantive law and just thinking about going to court. I'm just going to digress for a moment and talk about this fundamental issue between what you charge as a lawyer against what you want to do as a lawyer with a social conscience. And I've got to say that very often I think, and I was certainly guilty of this for many, many years, because you want to do the right thing by your client, it's extraordinary the amount of work that lawyers do for free. I don't think lawyers are recognised for this in any meaningful way, but lawyers do so many hours for free as a result of social conscience. And I think the message here is just be careful, because later in the unit, as we did early on in week 1, we'll be talking about balance and resilience. So even though tonight we're talking about social justice, access to justice, being creative in different ways that we can resolve matters for a client, and putting all of that over the top of the substantive law and the procedural law, remember also you've got to be fair to yourself, your family, your employer, and therefore don't undervalue your time. Don't be quick to do favours for friends or family. Maintain professional relationships from the outset. Agree on an hourly rate. Do the work professionally. Do the work promptly, and send the bill promptly for your work. So by doing work for free or heavily subsidised rates, you may intend to do a favour, but it might be counterproductive. It may be that it creates embarrassment. They feel that there's a feeling they can't brief you because they're taking advantage of you, or it may be that you resent the work that you're doing. Gary asks a really good question. What's the average hourly rate? It certainly depends on the type of work that you're doing. One of the best ways to do this is have a look at the court scales. That'll give you a really good idea. So if you do some research on court scales in the Supreme District Court, Magistrates Court, Federal Circuit Court, you'll get an idea of what lawyers are regarded as being worth by the courts. But, you know, somewhere in the order of, on scale, which is generally lower than what people would otherwise charge, you know, $250, $300 now, that type of thing, just as a general guide. So, even though I'm talking about access to justice, think about your responsibilities to yourself and others, and don't be shy in sending bills. Don't undervalue your time. All right. Now let's look at this idea of holistic advice within the context of being fair to yourself and others around you, and think about what are some of the issues that relate to giving holistic advice. So holistic advice means that I'm asking you to really broaden horizons now hugely and think about different ways of resolving disputes, different approaches that we might undertake. I guess the first thing that you need to do is be aware of different litigation or ADR options, which, if you like, is like a legal triage, isn't it? Someone comes to you for a problem and you've immediately got to make some assessments. How serious is this? What can we do about it? What are the different types of approaches? Am I the right person? Can we outsource this? Whole range of things. Can the party afford it? So number one, you need to think about different options, both for litigation and alternative dispute resolution. And then the second thing is you need to tailor this to the needs of the client, because the same dispute may result in different approaches depending on the nature of the client. And it may be dependent upon the nature of the case. So if your client says, I'm here to pursue a $100,000 debt, your approach might be entirely different when you ask the next question, who owes the money? If the response is, it's my son, your approach might be different than it's my commercial tenant who refuses to pay the rent when I know that they've got the money. Do you understand the difference? So Gary says it's essential to ask the client what's in the end. That's an excellent question. And what do you want is a really important question to ask. Especially for contract and family law areas, they provide options and they can raise ethical issues as well. Yes, I'm glad you mentioned ethics, Gary, because again, on top of all of this, we've got the procedural law, we've got the substantive law, you've got to be fair to yourself, you've got to be fair to others around you and close to you, and you've got to do whatever you do, you've got to do ethically, which comes in next week in our discussion. Number 3 in the discussion about holistic advice is, does the law provide justice for all that comes before it? Number 4 is the client acting upon emotional logic And that's a difficult one, because if your client wants to pursue an action that's not really worthwhile, but wants to pursue the principle of the matter, is that going to be, how will you feel if you send a bill for $50,000, knowing from the outset that it's likely to have been wasted money, but you pursued it because the client said, I want you to pursue it for the principle of the thing. You know, people do tend to fight for the principle until they actually have to pay, and then they back off a bit, which is another good reason why you've got to be upfront with the costs and realistic in terms of what it is. So again, you're looking to cater for the circumstances of the client, their intellectual ability, their socio-economic situation, their age, cultural factors, etc. So that's number 5. Number 6, are there capacity issues that should be considered? So if you're dealing with a person who's borderline intellectually disabled and they've just received a very substantial compensation payment and they want to pursue litigation that's unrealistic, you know, defamation against somebody who's got no money, clearly, question is, what do you do? So there's those broader issues as well, but that means you making some assessment of the individual that you're dealing with. All right, so when you then ultimately are in a position to have to give advice to a client, you want to talk about legal rights, legal obligations. You certainly are likely to want to talk about your ethical obligations, your legal fees, be upfront with them as well. And sometimes it's a matter of, and this is number 7, identifying the difference between that which is ideal and that which is realistic. Now, that's taking a holistic approach to the administration of justice. Yes, it might be ideal to pursue this case, but ultimately, is it going to be the best result for you? So number 8, as an advisor, there may be a question as to whether you should consider traditional legal and non-legal options for your client. I was certainly never taught this in law school in the 70s, but is there some non-legal option that you should be presenting to a client? If, for example, you do involve yourself in litigation, the client has a $20,000 bill, and then the client says, I've just been told by a friend that I could have actually gone about it differently. I didn't have to go to court. I could have gone to a tribunal or an ombudsman or something else. How are you going to feel at that stage? So in order to assess whether to pursue the matter by legal or non-legal option, you need to be aware of what those non-legal options are, as well as the legal options. So that means tailoring the legal services to the specific problem that you have. You need to consider whether early intervention strategies might be considered and other ethical obligations. Right, so let's think about now some options that you might adopt. Someone comes to you with a problem and says, I've got a consumer debt, I've got an issue where there's a problem with someone else. What are some of the general options that are available? Number 1, and this is not often actually discussed, but should be, I think, at least considered, is there may be an option to walk away from the dispute. In other words, the amount of money involved, even if it's substantial, may mean that it's better not to pursue the debt than to pursue it. Because there's a cost, isn't there? To pursue the debt, there's a cost in terms of financial and emotional terms. There's a cost in terms of having to provide instructions, come up with documentation, attend court, go through the trauma of the court. Now, I'm not suggesting that this is something you would say lightly, but you may at least need to consider it. So option number 1 may be to walk away from the dispute. Number 2 might be, look, I can assist you, but why don't you make a direct approach? Perhaps we can discuss some of the things that you might want to consider if you do that. It's never easy to do, but it might be the best way to resolve the dispute. Now, it might be as simple as sorting things out over a cup of tea or a beer, or it might be more involved than that. But as a lawyer, sometimes you may be better off taking a secondary role and asking your client to take the lead, as it were, for a variety of reasons. So that's maybe the second approach that you might consider. Now, the third approach, and Glyn's read my mind on this, is mediation or some sort of ADR process. I'm going to digress for a moment because this is number 3 strategy, mediation, and refer you to a thing called NADRAC and NADRAC publications. I'll share the screen. So when it comes to all things ADR, a good starting point is NADRAC. It's now no longer in existence, but its legacy lives on, and it was the National Alternative Dispute Resolution Advisory Council. And you'll see on the website that I've reproduced there, from the Attorney General's Department, Commonwealth, NADRAC publications, A to Z, and publications by date, and they work in quite neatly at a Commonwealth level with the Civil Dispute Resolution Act 2011. So if you're looking for some general guidance about what's involved in ADR generally, including mediation, what are definitions of the terms, etc., NADRAC is a pretty authoritative source. Okay, so mediation, says Glyn, is something we should consider. It's the third general approach. Mediation might be 1 or 2 mediators, generally 1, but it can be 2. Mediators guide the discussion. Typically, they don't sit in judgment, and parties are generally required to consent. So there is a free service, the Alternative Dispute Resolution Centre, or there is the option of paid services. Now, client comes to you and says, I've got this legal problem, I want you to help. Again, we're thinking holistically here, we're thinking very broadly. Another option may be to say, perhaps you could take this up with your Member of Parliament. In other words, if you can convince your Member of Parliament to advocate for you, then you've got a very valuable, authoritative source on your side to assist you in this argument. So if, for example, your complaint is that of a consumer who has a problem with an organisation, it may just be that the Member of Parliament at the time has a real interest in this and is prepared to go to bat for you, have his or her office make some calls for your client, etc. And sometimes, you know, these things can be resolved more quickly using that political approach than they can be through the legal approach. So that's the number 4 option, general terms. Number 5 is to make a complaint, but not directly to a Member of Parliament, but to a member of the executive. So, for example, the Office of Fair Trading or the Australian Competition and Consumer Commission. So maybe making a complaint to a general commission of that nature would be useful for you. So that's number 5. Number 6, we've heard of Ombudsman, I guess. So let's have a look at a website now for the Queensland Ombudsman. And I'll share the screen. So the Queensland Ombudsman says, standing for fairness, what we do, how to complain, improve public administration, etc. So the Ombudsman service is there to essentially adjudicate between disputes between members of the public and government at various levels, including universities. So it's to make sure that our, what the Ombudsman service says essentially, that it's to make sure that public agencies State government departments and bodies and local councils act fairly, make the right decisions for Queenslanders, and complaints to the Queensland Ombudsman can be made by phone or email, online, etc. So there's the website for the Ombudsman. I'm going to continue to share the screen because it may be that we need a particular type of Ombudsman to assist us with the complaint. So this is number 7, the telecommunications industry Ombudsman might be able to resolve matters involving a complaint with a telecommunications provider. And you'll see the big yellow-orange button, Start a New Complaint. And over on the right-hand side, complaints we can take, complaints we can't take. Below that, a guide to complaints process and common terms and useful links. So the message for tonight is we've got to think broadly in a whole range of areas. And it may be that when your client comes to you and says, I have this particular problem, that going to court is a less effective option than going to the telecommunications industry ombudsman. Let's have a look at another example. This is number 8, the Financial Ombudsman Service Australia. So this was by a different name previously, but from November last year, all new financial service complaints are dealt with by the so this was the previous service. Now it's the Australian Financial Complaints Authority. And so I should really give you the website for the Australian Financial Complaints Authority because that's where the complaints are lodged from the 1st of November. And prior to that, last year, it was the Financial Ombudsman Service. So that may be another option for you. Now, the next one is, and this is number 9, it might be an insurance complaint. And you'll see there that the Australian Financial Complaints Authority considers complaints about life insurance or general insurance products. So the idea of this is that it provides an opportunity to make complaints in relation to a wide range of insurances. It does not consider private health insurance. That's where you need to go to the Private Health Insurance Ombudsman. And it doesn't consider complaints about workers' compensation. That's where you need to go to the Fair Work Ombudsman. So number 8, in general terms, relate to ombudsman services in relation to insurance, private health, and fair work. And the idea is that it's a service that assists in resolving disputes between consumers and insurance or financial providers generally. And it's certainly something to consider. Now, what if the complaint, this moves on to number 10 now, relates to energy? Well, what we might then do is go to the Australian Energy Regulator to make a complaint. This is if you're having a problem with an energy service, a retailer or distributor. And again, you can see that there's the option of making the complaint online, and there's a lot of information there to assist you in that process. Now, all of these, if you like, work in conjunction with general principles such as the Australian consumer law, and there's always the issue about going to the Australian Competition and Consumer Commission. From Queensland perspective, we have I'm getting ahead of myself. I'll stay where I was. We have the Electricity Consumer Rights and Complaints Organisation. So I'll just stop there for a moment. You get an idea here that there's a broad range of people to whom you might direct your complaint. Going to court is not always the best alternative, and you need to consider about all of these because it may be the best way of resolving the issue. Something that's probably overlooked a little is the opportunity to encourage your client to go to the police. So if your client says, I've been ripped off, I want you to sue, maybe the appropriate course of action is to go to the police and make a complaint. Because if the police choose to prosecute it and successfully do so, it may be that as part of an order made by a magistrate or a judge, there may be a restitution order, and that may be a far more effective way of recovering the money than you going off and suing. So, but you've got to be really careful here. Can anyone think about why you need to be extremely careful about involving police action on behalf of a client rather than necessarily just suing? This is to wake you up, give you something to think about. Any idea where you can come unstuck? All right. A trap for young players here is to write to the other side and say, we're giving you one last opportunity. If you don't pay the $20,000 that you owe to my client is going to take you to the police. You can't do that because that's perceived as a threat. Extortion, exactly. So just be very, very careful. So if you recommend going to the police, don't let the other side know. Simply encourage your client to make the complaint if that's what your client wishes to do. Now, so that's number 11. Now, I'll share the screen again. We mentioned a few times that all of this has to be done within the context of with whom you're dealing. And it may be that if your client lacks capacity, you need to consider making an application for the appointment of a substitute decision maker. That would be through QCAT. There's a lot of information here on the Office of the Public Guardian website. It used to be the Adult Guardian, now it's the Public Guardian. And that will give you information about guardianship, decision making, restrictive practices perhaps, and generally about people making decisions for others with impaired capacity. Now, all of this, so that's number 12. Number 13, all of this has to be done within the context of human rights. So always think about the Queensland Human Rights Commission. We have the new Human Rights Act coming out shortly. Well, it's part of our legislation. It will become effective very soon. And this used to be, in part, the Anti-Discrimination Commission. It's much broader now, in my view. And this is an excellent website because it provides you with a lot of general information that you need to consider in relation to many circumstances. Now, coming back to financial matters, we have the Superannuation Complaints Tribunal, which is another option. And I'm out of order here, but the basic rights. Queensland provides assistance in relation to social security and disability discrimination services, and they can support and provide assistance. If we're talking about people that are older, then we have the Seniors Legal and Support Service through the Queensland Government. That's a very good service. I know in my local area, it's a very active service and provides a range of options and services and advocacy for clients. Then we have also through the Queensland website, financial literacy and resilience services that might help people with credit issues that are outstanding. So the whole range of things that you need to consider. Then once you've decided what that you're actually going to court, it's not just a matter of going and initiating the court proceeding. Tani's asked a good question. Can anyone advocate for a person, or it must be a professional? Generally, it must be someone who is accredited as a lawyer and has a legal practicing certificate, but it need not always be. So, for example, if you're dealing with something in a tribunal matter, it may be that someone else, like a property manager or someone else can be the representative, say, for a body corporate. If it's someone who lacks capacity, then it may be that a guardian or an administrator can be essentially the advocate, Or generally speaking, there's a thing called a McKenzie Friend. The McKenzie Friend is someone who's not a legal practitioner, but has the authority of the court to step into the shoes of a lawyer, as it were, in a limited way. So we call that the McKenzie Friend. All right, so before you issue proceedings in court, even if you decide eventually after considering all of these different options that it has to be court, again, there are a few things that you need to consider. Do we start by sending a letter of demand? Can anyone think about a reason why you would send a letter of demand first before you initiate court proceedings? There's a practical and financial aspect to this. Practical because Catherine says it might resolve things out of court. Yes. Rachel says it reduces costs. Gary says to notify the other party of the potential claim. Tani says because the other party needs the opportunity to respond. I agree with all of those answers. And take up Tani's point. If you don't give the other side the opportunity to respond, you initiate proceedings and they immediately say, you're right, here's the money, but I'm not paying your legal fees because you should have written a letter of demand. A court is likely to support that approach and probably not award you the costs. In fact, it may even be counterproductive because they may concede the matter and say, now we want you to pay our legal costs because you've dragged us to court. So letter of demand is potentially important. And another thing that you might consider instead of all of this, and this we'll leave it at this for tonight, is going to the media. It sometimes works and it might be seen as a last resort, but it sometimes works. All right, so next week we're going to talk about issues to do with ethics, and I want you to broaden your thinking again in terms of court work by having a good understanding of what courts deal with what actions. In other words, what is the jurisdiction of courts and tribunals? So, for example, if someone comes to you and says, I want you to pursue a debt for $5,000, where do you go? What if they want you to pursue a debt for $50,000? Where do you go? Your client wants you to sue as a result of a faulty refrigerator, $2,000, where do you go? What if it's a faulty motor vehicle worth $30,000? What if they want you to sue for an anti-discrimination matter? So if you have an assessment question for your take-home paper where I'm expecting you to give me broader information than just sue, sue and go to a court, that's not going to cut it. You need to think more broadly than that. And if the question calls upon you to give advice about litigation options, I'd expect that you have some idea of where the matter should be taken. In other words, which tribunal or court has jurisdiction to give you the order that you want. All right. Thank you very much. You've been very patient tonight. So next week, we'll talk about jurisdiction. We'll talk about ethics. Any questions about what we've discussed tonight before we wrap up? So those of you that have put in your second assessment, thank you very much. I appreciate it. Those of you who have not, and if you're watching this before tomorrow, the assessment is due Thursday, the 19th of September. That's tomorrow at 11:45 p.m. Late penalties apply, 5% per day for each day of late submission. And unlike the first assessment where there was no cut-off, there is a cut-off for the second assessment. If you don't have your response to me by Saturday evening, the 28th of September at 11:45 p.m, then I'll shut down Moodle and you won't be able to submit your work. So please make sure that you do, preferably on time. All the best, and we'll see you next week. See you then. Bye.